Hey guys, how is everybody doing? I'm sorry I closed the snack container. How dare I? But since I can't get her to eat anything else today, we doing it. How is everybody doing today? It is cold, it is rainy, it is shitty, but we have some tea to spill because Randy responded to the second motion to dismiss for subject matter jurisdiction. And he is not holding back. I read a little bit of it. He doesn't sound like he's getting snarky, which I like. He's going all in on the law, not necessarily the snark, which I love. Hey, Rogue Mama, don't be sent to Turtle Purgatory. Hit that like, subscribe, and share. We are trying to make it to 5K by summer. We are we are going up and down, but you can see things are disappearing. Oh yeah, and there will be a third. I am doing the my night court tonight. We are doing Zachary Young versus CNN, where CNN gets sued for defamation and actually goes to trial. Good to see you. Hey, how are you doing? Good to see you. All right, we are going to get straight into this because we are not going to waste time. We are just going to get straight into it. The good news is there are exhibits. I love exhibits. Alrighty, let's open this up. 80. You're silly. I am supposed to be packing, and I have 2 open boxes full of clothes. But I am thoroughly enjoying right now. I'm taking stuff off of hangers, and I have so many hangers, and I'm throwing away the bent, the broken. There is nothing better than throwing shit that is broken that you've been holding on to, and you look like, why am I holding on to this shit? Either donate it or throw it away. And I'm sorry, I'm not going to donate plastic hangers that are bent and broken. Like, nobody's going to want those. If you donate stuff, like if you wouldn't be willing to wear it or it's not in the condition to wear it, don't donate it. Turn it into something else. Turn it into a quilt. Turn it into anything. But if you aren't willing to wear it because there's a hole in the armpit, neither is anybody else. No, I don't use wire hangers because I grew up with Mommy Dearest. No more wire hangers. But, plastic ones, when you put pants on a hanger that's not meant for pants, and it starts to sag and breaks like that, and shit's just old. Yeah. Speaking of, welcome Mommy Dearest to the show. So, how is everybody doing today? All right, we're going to get straight into this. I just got to make it big enough for where I don't look so crazy. There we go. I'm going to do that. All right. I got to make it a little smaller because my eyes are like, holy crap. All righty. Response to defendant's second motion to dismiss under FRCP 12B1 for lack of subject matter jurisdiction. Grounds. Pants on the ground. Not going there. But thank you, Ung Hung here, for the $2 super chat. I know, and you saw they're all at the new house. So, yeah. Nope. It usually takes a few minutes for YouTube to send out notifications if they're going to at all. So, you have that 5 minutes, 10 minutes of every every live stream that you wonder why people are, just talking, shooting the shit, doing whatever, interacting with chat, because YouTube is slow on the uptake. And sometimes it takes a while for people to filter in. So, yep, grounds, if you know, you know. If you know. This is him responding to the motion to dismiss, not the Bubbles has filed so many motions. I know they get convoluted, but that was the motion, the motion to reconsider moving it to Gainesville, even though it's already in Gainesville. This is document 67. So we're on document 80. This is document 80. This is responding all the way back to document 67. So it's so yeah, Rick, this is completely different. So this is oh yeah, that happens to me too. I get Rumble notifications like either right on the time or a day or two later. So speaking of this, I get notifications from YouTube on when I go live on my own channel. Somebody make that make sense to me. Why would I need a notification that I'm live when I know I'm live? Because I'm the one who's doing it. But hey, YouTube is weird sometimes. All right, this is going back all the way to 67, which was the subject matter jurisdiction. And that's the stream where we looked up the definition on Cornell Law School's website of subject matter jurisdiction, so we all knew we were on the same page. Jeff, I need metal hangers. Can't find any more. I use them for filler when welding. Yeah, wire hangers. You got to go to like dry cleaners. All right. Plaintiff Jeremy Hales, in accordance with Local Rule 7.1e, responds to defendant's second motion to dismiss under Federal Rules of Civil Procedure 12b1 for lack of subject matter jurisdiction grounds and states, defendants seek a second bite at the apple following his second motion to dismiss, attacking the amount in controversy only. Defendants argue that the amount in controversy can no longer be satisfied due to the dismissal of plaintiff's extortion count, the plaintiff's purported admissions. Document 67. The motion should be denied as it is plainly without merit. The existence or non-existence of the amount in controversy required for subject matter jurisdiction is determined on the basis of the facts and circumstances as of the time that an action is commenced in a federal court. Under an easily stated, well-settled principle reflected in cases throughout federal courts, the existence or non-existence of the amount in controversy required for subject matter jurisdiction is determined on the basis of the facts and circumstances as of the time an action is commenced. And I love this highlighting or this bolding. Commenced. It's not what is now. It is what was back in March, because I believe that the first filing in this case was March 4th of 2024. So it's not now. It's what was then. Oh my goodness. 14B, Charles Allen Wright and Arthur Miller, R. Miller, Federal Practice and Procedure, Statute 3706, 5th edition, 2023, Lloyd v. Facebook, Inc., U.S. Appeals, Lexis. Sorry. There we go. 9th Circuit, July 8th, 2024. The dismissal of extortion count does not defeat diversity jurisdiction at this stage in the case. See if Budget Rent-A-Car Inc. versus, I know this is Japanese, and forgive me if you are of Japanese descent or you were in Japan watching this, but Higashiguchi. 9th Circuit, 1997. Events occurring after the filing of the complaint that reduce the amount of recoverable below the requisite amount do not oust the court from jurisdiction. And you would think that he would have figured this out. I'm sure they already are, or they're damn near close. Like, they gotta be up there by now. Different case, but Unhung Hero, thank you for the $2 super chat. Will he subpoena the state of Wisconsin too? Oh, he's in Colorado now, so. Subsequent amendments to the complaint or dismissal of certain claims, even if they reduce the demand to below $75,000. let's repeat that again for Bubbles all the way in the back, because I know you crazy asses watching, because you always watch, because you're creepy. Even if they reduce the demand to below $75,000, do not ordinarily oust diversity jurisdiction as long as the original demand was made in good faith. See, Bubbles, I know you're watching because you're a stalker, allegedly, but this is the one thing you will never understand about the difference between you and Randy, is this phrase right here. Good faith. You wouldn't know what good faith was if it ran you over like a Mack truck. Just saying. Just saying. Federal Practice Guide, Statute 1799 at 2C90, citing Paul Mercury Indemnity Company, 303 U.S. at 294-96. See also Budget Rent-A-Car, Inc. A claim made in the excess of the requisite amount made in good faith in the complaint satisfies the jurisdictional requirement. Even if events occurring after the filing of the complaint that reduce the amount recoverable below the requisite amount do not oust the court from jurisdictions. Hey, Gabby. I need something. It's raining today, so like the allergies are going nuts because it's like 40 degrees, but it's like 95% humidity. It's that cold rain. It's gross. And I've been moving stuff today, so wrong mama. Like, subscribe, share on X, Facebook, Insta, AOL Messenger. With that dial-up internet you got. Hey, AKA the cat lady. Squid is doing her best imitation of the fleas today. I'm so, yeah. I apologize so much for that. Oh, plus I just got done eating a little while ago because I knew this was going to take a while, so I wanted to cook before I did this. And I after I eat, the brain stuff always messes with the ability for my ability to swallow is not good. Ung Hero, don't even do it unless you're going to super chat it. You're coughing more than on bridge. Oh. All right. This court has already determined the original demand was made in good faith. There are few accusations that could be more harmful to a person than false accusations of essaying others, especially children. This is particularly true when false accused persons, business and source of income are directly tied to the number of people who view, support, subscribe to his social media content. That is 100% true. The more people that watch, the more ad revenue you get. The more ad revenue you get, obviously, the more money you make. Ung Hero, thank you for the $2 super chat. I'll let everybody read that, but I am not going to. It is not difficult to see how being falsely accused of ARPing children, along with the other defamatory statements defendants have allegedly made, could cause plaintiffs to suffer damages in excess of $75,000. See Moore v. Senate Majority PAC. Ooh. North District of Alabama, September 29, 2023, refusing to set aside $8.2 million defamation jury verdict where the defendant falsely stated in public advertisements that the plaintiff had solicited underage girls for fun time. Lustig v. Stone, Southern District of Florida, 2019. Oh, okay. I'll pick it up. Hold on. There we go. Yeah, somebody didn't take a nap today because they fight it. Would you like an ice cube? Oh, you want my phone? No. What do we want? What do we want? Girl, I can't get up right now. Mama's sitting down for 5 minutes, okay? Oh, we're having a day. She's fine. Excuse you? Come here, baby. Okay. You want another snack? Your pizza's on the table. She's just sitting here like, All right. Thanks, guys. I appreciate your... No, she's just sitting here fine. She just has her moment and she moves on. Refusing to set aside an $8.2 million defamation jury verdict where the defendant falsely stated in public advertisements that the plaintiff had solicited underage girls for fun time. Lustig v. Stone, Southern District of Florida, 2019, awarding the plaintiff $700,000 in damages for defamation where the defendant referred to the plaintiff publicly as an adult and like a child ARPer who had masterminded an attempted premeditated unaliving. When the possible actual damages are combined with the possible treble damages and the possible reasonable attorney's fees, the court easily finds that it is more likely than not that the amount in controversy exceeds $75,000. Emphasis added. Yeah, quick, Megan's hold music. I haven't listened to Megan's hold music in months. The motion should not be well taken. I don't think it will be. Okay, this is just me being picky, but like just the title on a bottom of a page just irks me. Side note. Even the statement in paragraph 19, which focuses on repeated defamatory posts with which the plaintiff has seen, was made in good faith. In fact, plaintiff's statements about defendant's defamatory social media post he has seen has evidentiary value and is uncontroverted. It is axiomatic that troubling social media posts such as those which accuse someone of being any kind of child a word that I can't say on YouTube would be deleted by the publisher. In fact, defendant Preston has already deleted her entire Facebook group called Otter Creek Friends and Neighbors, which prior to being deleted contained a social media post from defendant Preston to plaintiff that stated, 1, I am not a horrible person, Jeremy. I've never slept around, and that's why I was married so often. I mean, I'm sorry, but that statement, I was married so often because I don't sleep around. I just... It's a head scratcher right there, but that's a whole side note that we don't have to get into. Bye. Oh my goodness. Bye. Guess what? You ain't welcome here anyway. Bye. You done. Thanks for letting me know you're unsubscribing when, guess what? I didn't give a shit about you anyway. I didn't know who you were 5 seconds ago, but yet you decided to grace us with your presence. I don't know. Let's see. I got nothing. I don't know. People feel the need to hate or rage quit, which is kind of funny because I'm sorry, like I love everybody here. However, the fact that I didn't know who people, yeah, it's not an airport, no need to announce your departure. It's just one of those situations of like, I love rage quitters because it's like, not everybody in life is going to get along, and that's fine. However, when you feel the need to be blatantly rude and disrespectful because you don't like me, you need I packed up my Giphy, but Rosalind needs to put you on the Giphy award list. And if you don't know what a Giphy is, it's the Go Fuck Yourself award. You didn't let them vent it all out. You should have just ignored them, and they thought, you're ignoring me. Let me post again. Guess what? I don't care. He's only timed out for like 5 minutes. So if he still wants to come back and tell me how much I suck, bring it. Because the more you comment, the more you help the algorithm. And the more you help the algorithm, the more people see my comments. So like, goodbye. He's always been kind of a hater, though. I think he's commented, before. Bye, Felicia. Baby Squid's not the only one having a tantrum. Hooptula, how are you? I just subscribed to fill this spot. No love lost. Oh, and see, that's the thing. Like, I'm sorry. I'm having a coughing day. I am busy. It is raining and nasty outside. Like, y'all, it's that kind of a day. Kathy, thank you. Don't worry about it. You're doing a great job and you're a great mom. Everybody here knows you have a life on your channel. Yeah, and that's the thing. Like, sometimes she's yep. Megan tells everyone to send a rage quitting email. I'd prefer people not spam my inbox, but it would be nice to have just on a Sunday night, unhinged stream, just put all the rage quitters emails up and just expose them, because that's the kind of person I am. All right. John is his own man, and I don't know why Jeremy attacks me due to John's behavior when he knows the truth. Again, we do not live in filth or a garbage dump. The pictures speak a different story, but I do not and have not ever beat my baby daughter. Shame on you, Jeremy. John is not a registered person or one of those, but or PDF file. But I find it funny you hang out with the men that are, and you yourself are disgusting towards children, mainly focusing on. Yep, I am my own person. See Exhibit 1, emphasis added. Defendants alleges that plaintiff fabricated these allegations out of thin air. In reality, defendant Preston made her defamatory statements about plaintiff disappear into thin air, and discovery continues. Sorry, that's hilarious. This is being snarky, but in petty, in a professional way, because it's stating a fact, but it's my kind of petty, and petty knows petty. That's how I knew that dude was just being petty, because oh, and I'm sorry if that dude's ever coughed in his life. God help us all. Oh, he must have been one of those people that wore a mask and gloves while he was in his car by himself in 2020. And one of those people that disinfected your food. He was one of those. I like you because you're honest and real. Keep on smiling. I will never, I just can't, I just can't not be honest and give you my true thoughts. So sometimes people, I honestly, I don't know what his name was. I can't even remember. Shade, it's shade. Yeah. Shade. I love it. I love the shade that's put in a professional way. I promise I'll keep my germs off the internet. This shows that the motion should not be well taken, as it is simply without permit a party who has already been shown to delete their own post and an entire Facebook group, petty but true, made in social media to falsely claim that their opponent is being untruthful when they state they saw a defamatory post before they were deleted by the publisher. Furthermore, the complaint does not hinge on whether or not repeated posts were made. Regarding the motion's claim that plaintiff cannot identify a single person who saw the defamatory signs other than Zim Padgett, Therese Granger, and Stephen Granger, defendant's counsel disproved this himself recently in the deposition of Miss Amanda Martin, defendant Preston's court-appointed victim's advocate. an employee of the 8th Judicial Circuit in the state of Florida, who testified that she saw the signs when the social media posts and links to the defamatory signs were sent to her by 2 different people via email. Oh, somebody screenshot that. Yeah. Hey, Spawn, how are you? Oh, my goodness. Oh, hey, Yeety, somebody got yeeted. Oh, snap. Yep. Oh, my goodness. See the transcript attached is Exhibit 2. We will get there. Regarding anyone directly contacting Whatnot Inc. to use defamatory statements to interfere with plaintiff's relationship with Whatnot Inc., again, defendant's counsel has recently provided such evidence. This occurred Monday, February 17th, 2025, when defendant's counsel emailed Mr. Cam, a Whatnot Inc. representative, and stated, oh, sweet. Mr. Cam should know that you are dragging him and his company into your client's scam of a contrived litigation to create YouTube content for your client's storylines. Tell me he did not. Yeah, 1, I'm really bad at that. It just sounds ridiculous and stupid. And 2, things can only be done so many times before it gets old. And like, why watch somebody else if they're the same as every other channel? Mr. Cam may be interested to learn that as part of you and your client's litigation scam that you're now trying to involve Whatnot in, he committed perjury to trick the federal court into exercising jurisdiction by filing a false affidavit stating my clients made and were making online posts calling him a child rapist constantly and ongoing to this day. And that as counsel, you did nothing to confirm whether there were any such online posts before you signed the motion opposition that relied on the perjured statement. I would think any company would want to know if one of their prominent customers who regularly promotes his business with them is falsely using them to support fake lawsuits. Sweet Jesus. See Exhibit 3. I'm sorry, I'm floored right now. Like, what the actual fuck? Do as I say, not as I do. What the? Bye, Rick. I hope you have a better day. I just... Okay, to get a mental, like, palate cleanser. Cynthia Miller, thank you for the $4.99 super sticker. And you want to come up here and say hi? And Slug, thank you for the $2 super chat. This is why you're short, Squid. We demand geckos. Oh my goodness. It's okay. Miko. She likes to, this is technology girl, likes to use my phone to play music while she watches YouTube on her iPad. Oh, and this is the only time she's allowed to do this is when I'm on the computer, because I can't tell her not to be on technology when I'm on technology. Oh, everybody says hi. You want to say hi? Say hi. Okay. See you. See you. Defendants also purport to know that there were 41 minutes of daylight before the signs were removed. This is evidence that defendants are protesting too much from Shakespeare's play Hamlet. Thou dost protest too much. He literally quoted Shakespeare in him. Something I never thought I would see. He literally quoted Shakespeare. Hi. Oh, and for those of you who weren't here, this is the I started. This is the this is the dude who got yeeted. Just in case anybody he wants his 15 minutes of fame, I'm gonna give it to him. He literally quoted Hamlet in a legal filing. I mean, okay. because only someone who knew the date and time when these defamatory road signs were placed would make such a statement. I never made that connection, and this is why I'm not a lawyer. I never made that connection. I never made that. Holy crap. Volume down, please. Oh boy. Okay. I have to mute for a second because I have to turn the volume down on what she's. Thank you. I just had to turn the volume down before she gets me yeeted. We're an actual copyright strike. Yeah, Jeffrey, I wasn't gonna be long enough to play my hold music, so could also be just when daylight was the morning, making a guess. Yeah, I didn't. Well, in the filing, he said his defendants also purport to know that there were 41 minutes of daylight before the signs were removed. How would they know if they didn't put them there? It's kind of a telling on yourself that I just did not realize. This was a oh, the judge posted another ruling. Oh my goodness. We will check as soon as we get to getting. I will look. Nope. This is well. Yep, the order. Plaintiff's motion for summary judgment. Oh, okay. We'll get to that. We will get to that. I promise. But first, we got to get through this. Defendants' case law citations are unavailing at best and misleading at worst. Defendants rely on Shanagan versus Cahill, 4th Circuit 1995, but this is easily distinguished from this case. Shanagan involved a case where after the court other counts were eliminated, the sole remaining count was for an amount certain in liquidated damages, which irrefutably fell below the minimum amount controversy threshold. The trial court felt compelled to dismiss all of plaintiff's claims when one count was eliminated and the remaining liquidated damages totaled less than $50,000. Nonetheless, the 4th Circuit reversed the lower court's judgment and remanded and held it that the lower court had discretion to retain the remaining counts. Oh, he twisted it. He gave, oh my God, this dude, Bubbles did something that is why I need to get better at looking up the case laws or the case law that they cite. Because this was appealed. And oh my God, he really did that. He really did that. Like he really did that. Okay, I'm sorry, I'm floored. Like y'all are getting my he legit. This is where like you really got to pay attention to the case law, and that's why sometimes when it's like, "Ooh, I should look that up," to see if they are using, because I swear some lawyers seem to cite case law like is that case law even related to what you were talking about? And it's oh yay. Defendants also purport to quote from Rosado versus V. Wyman, Supreme Court 1970 by stating using quotes. In particular, it is important to consider whether the amount claimed in the complaint was made in good faith or whether the plaintiff was consciously relying on flimsy grounds to get into federal court. See Rosado v. Wyman, distinguishing initial insubstantiality from subsequent mootness. However, upon reading pages 404 and 405 of the opinion, oh, here we go, Brace yourselves, people, in Rosado v. Wyman. The purported quotation does not exist. On remand, the district court correctly considered mootness a factor affecting its discretion, not its power, and balanced the policy considerations that have spawned, pun intended, the doctrine of pendency and the countervailing policy of federalism, the extent of the investment of judiciary energy, and the character of the claim. Not only had there been hearings and argument prior to dismissal of the constitutional claim, but the statutory question is so far essentially one of, quote, federal policy that the argument for exercise of pendent jurisdiction is particularly strong. United Mine Workers v. Gibbs, 1966. Respondents analogize. Now, make an analogy. Dismissal for the mootness to dismissal for want reading is hard. Substantial claim and rely on the language in United Mine Workers v. Gibbs. My brain is moving faster than my mouth can, which is random. To the effect that a federal court should not pass on a state claim when the federal claim falters at the threshold is, quote, dismissed before trial. The argument would appear to be that once a federal court loses power over the jurisdiction conferring claim, it may not consider a pendent claim. They contend that mootness, like insubstantiality, is a threshold jurisdictional defect. I'm sorry, this is very well written. It has the snark, but it's the professional snark. And it's the kind of snark that I can get behind. Whether or not the view of that insubstantial federal question does not confer jurisdiction, a maxim more ancient than analytically sound should now be held to mean that a district court should be considered without discretion as opposed to power to hear a pendent claim. We think that the respondent's analogy fails. Unlike insubstantiality, which is apparent at the outset, mootness, frequently a matter beyond the control of the parties, may not occur until after substantial time and energy have been expended looking towards the resolution of a dispute that plaintiffs were entitled to bring in federal court. I never thought in my life that I would hear somebody argue the word moot and how mootness impacted a case. But here we are. Hey, Tammy, I missed you this morning. If you would have been here, my whole crew of Tammys would have been here all at the same time. And Edie, thank you for the $2 super chat. They say the swallow is the bird of love. LOL, sorry. Sorry, that took me a second. This is why, yeah. Oh my goodness. I just, yup, bros made up a quote. Yup. That happened. And this is why people hate lawyers. This is why lawyers get a bad rap. I forgive you, Tammy with an I, just this once. Deuce Boy is done. This is it. No more free goes. Go to jail, pass go. Do not collect $200. You are the weakest link, Deuce. The keel nose masking. Never too many Tammys. I love my Tammy crew. I was getting a David crew too, but I haven't seen them in a while. At least I'm the only Edie. We are not willing to defeat the common sense policy of pendent jurisdiction, the conservation of judicial energy, and the avoidance of multiplicity of litigation. That should be what Bruce uses, not his polo poop. By a conceptual approach that would require jurisdiction over the primary claim at all stages is a prerequisite to resolution of the pendent claim. The court has shunned this view. See Moore v. New York Cotton Exchange, 1926. Ooh, that was a throwback. And Hearn v. Ausler, 1933. It's also a throwback. Rosado v. Wyman at page 403 to 405. The particular words in the motion relies upon when citing to Rosado v. Wyman as being in support of their motion does not exist in the cited Rosado v. Wyman opinion. I couldn't think of what it is. I can't think of it. That's the first thing that came to my head. Yeah. Well, those throwbacks show it's been settled a very, very long time ago. Yes. Almost 100 years in that one case. If she does, she's the first member because I eat things. All right. Getting back to it. Yeah, if you like the chaos, but the chaos of just making fun of what's written in the motions and not the people themselves, yeah. Polyflop. Consciously relying on flimsy grounds to get into federal court appears nowhere in the cited Rosado v. Wyman opinion. Consciously does not appear in the cited Rosado v. Wyman opinion. Relying on flimsy grounds doesn't appear. Good faith does not appear. Defendants have obviously fabricated these phrases from the whole cloth while presenting them as purportedly being from the United States Supreme Court opinion. Oh. Yeah, I saw it. We're going to get to that, but we have to get through this first. Because I hate, even though I get sidetracked and I get sidebarred, I want to get through one document and the exhibits before we move on to something else. Otherwise, nobody's brain can keep up. That's like skipping around in a textbook. It's just hard to do. At least when I sidebar, I'm still on the same page. Exceptionally, defendant's use of a quotation mark misleads this court into thinking this is a direct quote from the cited opinion. That it does, because usually when you use a quotation mark, it's because you're quoting something. Just that whole English, like 6th grade English class. Damn grammar. This also should not be well taken. Moreover, this is not the first time defendants have done this while attempting to argue the minimum amount in controversy. I like when Randy does this. And I think he might have taken a page from the judge doing this, but I would rather have him. And I'm not a lawyer. This is just my opinion of what I view as petty. This is a way to make your point and be kind of petty without like being snarky and pissing off the judge. Defendants have made a bare bones allegation that the complaint has no allegation establishing the minimum amount in controversy for federal diversity jurisdiction. Motion at page 3. In doing so, defendants misstates and misrepresents the law to this court by citing an opinion which does not exist. It's like, sit down, you don't exist. It's not sit down denied, it's sit down, you don't exist. Defendant's misrepresentation shall not be well taken by this court. Should not shall not. Language is important. Words matter. The motion states, C. Lee Memorial Health Systems v. Lexington Insurance Company, Middle District of Florida, March 7th, 2019. This is just the case number, and it doesn't require me to read it. Other than the conclusory statements in paragraph 2, there is no factual basis for the court to conclude the jurisdictional amount is satisfied in this case. However, the document from that case from March 7th, 2019 contains no such statement and is simply an order denying consolidation. See document 8 and document 9. See also document 54 and 50, or at 15, line 1. Even if defendants had not misquoted from Rosado v. Wyman, that opinion is nowhere near analogous to the facts in this case. This is because in Rosado v. Wyman, the Supreme Court held that the district court retained jurisdiction over a pending claim after it declared moot a constitutional claim. Rosado v. Wyman is not based on diversity jurisdiction and the amount in controversy. And this is why sometimes it takes judges a lot of time to respond to things, or other lawyers time to respond, because this is the shit that they look up. This is the shit their paralegals look up. And this is why it's also good to have a really good paralegal, because as a layperson, we look at this and go, okay, they used case law, okay, to support their point. However, eh, eh, it's yeah. It's just one of those things that, like, you gotta fact check the case law. And when they're big long cases that have made it all the way to the Supreme Court, you're looking back not just at the Supreme Court decision, but my assumption would be you're looking back at the lower court's decisions too, to see what was said, or what those opinions said, or what was done by the lower courts and by the attorneys involved. And yeah, this is why sometimes it takes so long. So we're like, why are we reading a document that was responding to a document 13 documents ago? This is why. These things sometimes take a while. I'm betting every document filed by Bruce is going to be reviewed again, scrutinized, and examined. Oh boy, is he in TROUBLE. Yeah. And I don't think Bruce is alone in this ethical issue, but I believe this is an ethical issue, because it's one thing to interpret a case differently than another lawyer, but to put quotes in a motion that there is no actual quoted, the quotes don't exist. Yes, credit where credit is due, Doreen. So you can't get me copyright struck for the music, baby girl. No. She loves her music. She loves music. In fact, the insubstantiality addressed in the cited Rosado v. Wyman was that of a federal question, not the amount in controversy. For the reasons above, it is respectfully requested that defendant's second motion to dismiss under Federal Rules of Civil Procedure 12b1 for lack of subject matter jurisdiction be denied. I mean, that was very well written. It had the snark without being unprofessional snarky. It was very here's the law, and here's what this motion said versus what was written. They don't match, and that's on him. All right, so we have the I have to just download. Thank you for sending me the screenshot of the and thank you, Max, for sending me the updated, or at least letting me know, sending me the updated things. So we are going to go through the exhibits. There's 3 of them. I have to download them, because I downloaded the motion and started reading, but I did not read through the all right, we are going to do this. I'm going to open them all first so that it's just super easy to go through them. Because if I have to go through and look at my downloads, it's just going to be confusing for me and confusing for y'all. And we have so much to get through and so little time. I got to close that. And these were mostly stated in the hi. You gonna hit me? Achoo. Achoo. Can you hear her? She's going achoo. Achoo. Here is 80.1. This is from the Otter Creek Friends and Neighbors Facebook page. We read these, so I'm not going to read them through again. That this is the original. Y'all can, yeah. I will post it. I have to update the Discord. I've been slow because obviously the things are disappearing. Jeffrey, thank you for the $5 super chat, helping with the funding for Pacer documents and applesauce, bananas, candy, donuts. Thank you. I appreciate it. This is 80.2. And I appreciate all your super chats and your likes and subscriptions, because I realize that is not a, with the super chats, that's your hard-earned money that you're sharing with me because you appreciate what I do. So I never, just know none of that is ever taken for granted. This is 5 pages of a transcript. And I don't have the whole transcript, but if I can get it, damn sure I will be reading it, but I have to ask people for it, and people just don't share things like that with me because I'm not part of the cool kids club. Excerpts of deposition of Amanda Martin taken on behalf of the plaintiff. Happy Valentine's Day. Where Amanda Martin acknowledged having been duly sworn, tell the truth, testify, direct examination. And I don't have anybody else to read this, so we're just going to read it plain. And if we get the full transcript, we will be doing a dramatic reading with somebody. I might invite Brad back because Brad is fun and I haven't talked to him in a while. So, in your office, did you hear about any road signs in town around Otter Creek? No. You just heard there was a case? Yes. But Mr. Matskin, do you have any knowledge about road signs, handwritten signs calling Mr. Hales a child rapist? To be very honest, only through some of the YouTubes that have been sent to me since all of this. I didn't know anything about it, any of that when this was going on, so just since that. And since then, what compromises your knowledge about this topic? Is it just seeing YouTube videos? She says that is it. On your own, or you say that people send them to you? Yeah, I don't go and look for that. Who do you receive YouTube like links from that prompt you to watch something? I could not tell you by name. I just have very bored friends in life. Oh my God, I have it. This is part of the transcript. This is just an excerpt. Read by not an expert, apparently. Duncan Idaho, thank you for the 5 Squid Pro Quo memberships. Oh my goodness. But based on this transcript, the full transcript should be fire. That's just what they do. They thought you might be interested, so they'll send it along to you, particularly with this whole what the hell's bad neighbors. She says, I call it a saga, but yes. And they repeat that. So you don't have any knowledge other than what you just described, watching some video clips on YouTube. Yeah, she says, yeah, and very minimal of that. I don't have any knowledge of any signs. And then the certificate of reporter. Great. There's the transcript. And then, hey, Lisa. All right. And then the third one is the, this is the, this is the one that makes you speechless. Whatnot contracts from Bruce Matskin. And I didn't redact it. It was already redacted. Just, Mr. Shockett, I don't know what. Oh, my nations you're orchestrating by copying me on this communication. I have no obligation to provide a proposed order of confidentiality, although I did specifically provide a stipulation to maintain confidentiality in writing, but you ignored that because your purpose has been to exploit the issue of the production of this contract for as long as possible in order to waste time and create issues for court motions to generate YouTube content. Mr. Camp should know that you are dragging him and his company into your client's scam of contrived litigation to create YouTube content. YouTube content is his favorite freaking words. But dude, yeah, Max, I got it. We're just getting through these ones first before we go on to that one. Otherwise, the brain hurts. Like, the brain can't comprehend going back and forth between multiple motions and multiple orders. I have to finish one thing and then move on to the next. But we will get there. This is just, oh yeah. Mr. Cam should be interested to learn as part of your client's litigation scam. You're now trying to involve Whatnot Inc. He committed perjury to try to trick federal court into exercising jurisdiction by filing a false affidavit stating my clients made and were making online posts calling him a child arbist and constantly ongoing to this day. Well, every time you put it in a new motion, you are knowing that the motions will be read online. Keep contriving it. This is just, it's just this. And as counsel, you did nothing to confirm whether there were any such online posts before you signed the motion opposition that relied on the perjured statement. I would think any company would want to know if one of their prominent customers who regularly promotes his business with them is falsely using them to support fake lawsuits. Yay! Yay! Congratulations! Yay! Oh my goodness. So happy for you. Yeah, this is what he sent to Randy. And I guess he was CC'd on an email from Shockit to Mr. Cam from Whatnot. It's like, it's ridiculous. I invite Mr. Cam to reply here stating whether he or anyone at Whatnot has any information about either of my clients, John Cook or Michelle Preston, contacting Whatnot or anyone else contacting Whatnot for the purpose of attempting to interfere with Jeremy Hill's What the Hill's business with Whatnot. If Mr. Cam or someone on behalf of Whatnot would call me so that I may inquire about that single question, I think there would be no need for me to subpoena him for Whatnot documents or deposition. Mr. Cam may reach me at whatever number. Never mind. If he prefers, I invite him to call me along with Whatnot's legal representative or to forward my name and number to the appropriate person to contact me. An informal call should be all that is necessary to avoid further involvement in this nonsense that you are trying to cause with your email. On February 17th, somebody wrote, "Hello, Mr. Cam. I represent Jeremy Hales. Mr. Hales is a plaintiff in a federal lawsuit in which the defendants have requested that the agreements between my client and Whatnot be produced. The contract, as you know, requires the written consent of Whatnot in order to be produced and also requires it to be produced pursuant to a court order. We don't currently have a court order, although I have suggested to my opponent, Attorney Matt Skin, copied here, that we simply agree to such an order. There has been no proposed agreed order from my opponent. Attorney Matt Skin has requested that our firm draft a confidentiality agreement, and we will be doing so this week. We anticipate this will be signed, but please advise as to the written consent of Whatnot. Thank you. If you have any questions or concerns, please do not hesitate to contact me. Randy Shockett." Like, it sounds, see, and this to me just says Randy, like, said, "Hey, I know that y'all need a court order. I'm just giving you a heads up." Like, yeah, because they need the written consent of Whatnot. Like, it's just one of those, like, to me, this is just giving them a heads up of, hey, this is happening. Do you consent? Will you sign a consent, or do we need to get a court order? Like, and CCing Bubbles on it was professional courtesy. Hey, Jen, how are you? Like, to me, that's just professional courtesy. Unlike blind carbon copying random YouTubers, well, not random, I guess I was random, but YouTubers on an email for a settlement, that is not professional courtesy. That is shady as shit. So one person did it. One person did it as a professional courtesy, i.e. shock it to whatnot. And the other person did it as a shady as shit, low blow move. Yes. That right there. Hi, honey. You want to come up on Mama's lap? Okay. All right, and then we have the new order, plaintiff's motion for summary judgment. Hold on, boo boo. Hold on. Let's see. No. My thumb doesn't. My thumb needs to stay attached to the rest of my body. All right, we have this document that we will get through quickly. It's 6 pages. I have 15 minutes. So, or 20 minutes before we got to go. All right. This is a new order from today. Supposedly the walrus's contact whatnot. Well, I guess all the data doesn't lie. Phone records don't lie. Metadata doesn't lie. Yes, this is the new order from the judge that was filed today. Document 81. Order presently before the court are plaintiff's motions for summary judgment as to defendants' counterclaims and supporting memoranda. Documents 73, 74, 75, 76, and 77. For the reasons below, the court will strike plaintiff's motion for summary judgment and supporting memoranda. After their motion to dismiss was granted in part, defendants answered plaintiff's complaint on February 8th of 2025, documents 69 and 70. In their answers, defendant asserted 3 counterclaims against plaintiff, including 1, the intentional infliction of emotional distress, which I feel is what Bubbles is doing to all of us. Unauthorized use of defendant's likeness under Florida Statute 540.08, and 3, common law invasion of privacy by unauthorized publication of defendant's likeness. A mere 3 days after the defendants asserted their counterclaims, plaintiff filed motions for summary judgment and supporting memoranda, primarily arguing that defendant's counterclaim failed for lack of evidence. The deadline to file dispositive motions in this case, including the motions for summary judgment, is April 28th of 2025. Yet both sides, plaintiff and defendants, have now filed summary judgment motions before the full development of a record as to the claims and counterclaims at issue. The court is concerned that both parties are filing early summary judgment motions with plans to file more summary judgment motions later in the litigation. Because it consumes substantial judicial and litigant resources early in the game, this piecemeal strategy of filing motions for summary judgment near the inception of the claim is highly disfavored. See Middlegate Development LLP versus Bede. Southern District of Alabama, August 9th of 2011. Allstate Financial Corp v. Zimmerman, 5th Circuit, 1961. Footnote. Always love this judge and his footnotes, so we will get there. We certainly do not approve, in general, the piecemeal consideration of successive motions for summary judgment. Okay, interjecting my opinion, all successive motions do is give YouTube people content. So Bruce filing all these motions is what gives people YouTube content. If Bruce would not file all these motions, and Randy in turn would also not file these motions, the YouTube content would be minimal. Hence why some of my other cases I haven't talked about in a long time, because there's not a whole lot going on. There is pro hac vice motions and motions to withdraw the attorneys. Nothing substantial that I need to make a stream for. But yet the What the Hell saga is an 3 times a week thing because people keep filing shit. People keep filing shit. Yeah, this is a giant quit it now. And none of this is well taken by the court. Which good thing. I really like this judge. I really like this judge. This judge is like a pissed off dad with toddlers. I told y'all to quit arguing. Like, I told y'all to quit arguing. Just sit down and shut up. I told you to quit arguing? No, I didn't. Like, I don't know if this is bad for Randy, but this is like a stop. In my opinion, this is a stop going tit for tat with Bruce, and just stop. Just let him file this shit and just let him make a fool of himself. Like, yeah, like a nun pulling out her ruler. If you know, you know, no. Since defendants might well normally be held to the requirement that they present their strongest case for summary judgment when the matter is first raised. Tibbetts Lumber Company, LLC versus Amerishire Insurance Company, Middle District of Florida, March 2021. Footnote, the Fifth Circuit decisions issued on or before September 30th, 1981 are binding precedent in the 11th Circuit. Bonner v. City of Pritchland, 11th Circuit, 1981. In this circuit, successive motions for summary judgment are disfavored. Other federal courts routinely prohibit successive summary judgment motions and provide litigants with one attempt at summary judgment. One. I think he's going for a record of how many docs he can file, going for the gold. And I just think that Randy is, I don't think this is normally Randy. I think Randy's going tit for tat because he feels like he needs to respond, which I totally get. But it's like, just let Bruce keep filing frivolous motions and making a fool of himself and stop making the judge think you both suck. Like, that's the thing about me and my pettiness, is like, when someone is being unprofessional, that's where I'm like, yes, sir, no, sir. Yes, sir. Yes, ma'am. No, ma'am. How can I help you? Is there anything else I can do? Like, that is when you are super polite, super respectful, and follow the letter of the law. Because that not only lets the other person be professional, it makes them look worse because you are being on your best behavior. So with him going tit for tat, it's like, it makes the judge be annoyed with both of them. But footnote 2. And while successive motions for summary judgment are not prohibited by the federal rules or controlling case law, a second motion for summary judgment is not permitted as of right, because successive motions promote piecemeal education and erode judicial economy. Mackenzie Wharton v. United Airlines Incorporated. Footnote 2. See Southern District of Florida, Local Rule 56.1e, filing and service of multiple motions for partial summary judgment is prohibited, absent prior permission of the court. See also Middlegate Development, LLP, stating that defendants who filed an early summary judgment motion will not be afforded a second bite at the summary judgment apple to raise arguments and present evidence. That's the second time we've heard a second bite at the apple in documents today. I haven't heard that phrase in a long time, and now I've heard it twice. Oh.
Mama.
That's me.
Mama.
That's me. Oh, baby. Oh, yeah. Guts. Yep, I'm going to get you. Yeah. Of course they will. But I have 10 minutes left, so we got to get this done. Will not be afforded a second bite at the summary judgment apple to raise arguments and present evidence that they could have and should have submitted earlier but did not. McCabe v. Bailey, Northern District of Iowa, April 2008, enforcing a one summary judgment motion per party rule to conserve scarce judicial resources, prevent repetitive motions, and forestall potential abuse of federal rules of civil procedure 56. And it also, so it not only conserves judicial resources, but it saves your clients money, because every motion you file, it charges your clients money. Somebody has to pay for that, and it ain't the lawyer, it's the client. Oy. Impreglon Inc. versus Newco Enterprises, Northern District of Georgia, 2007. This court has discretion to require parties to present their arguments in a single motion for summary judgment. U.S. v. Fisherman's Fleet Inc., District of Massachusetts, 2008, denying leave to file a second motion for summary judgment. This original case that we were talking about, Wharton v. United Airlines, was Middle District of Florida, 2016. C. Fernandez v. Bankers National Life Insurance Company, 11th Circuit, 1990, stating that a second motion for summary judgment is not prohibited when the judge allows such a motion, putting it in the judge's discretion. Once again, the judge's discretion. Awodaya v. Ross University School of Medicine, Southern District of Florida, 2021, acknowledging the presumption against successive summary judgment motions. I like this judge because he doesn't put one piece of case law making his point. He puts multiple from multiple states, multiple years. Like, this is not just a Southern District of Florida thing. This is a Northern District of Georgia. This is the District of Massachusetts. Like, this is not just me being pissed about this. Like, this is, yeah. Oh, wait. The court has inherent power to maintain control over its docket to ensure effective justice and prevent congestion. Young v. City of Palm Bay, Florida. Sorry, Palm Beach. It's Palm Bay. 11th Circuit, 2004. Because successive motions for summary judgment are disfavored and not allowed of right, and piecemeal litigation wastes precious judicial resources, the court will exercise its inherent power to strike plaintiff's motion for summary judgments and supporting memoranda. Like, less than a year and we have 81 documents. Less than a year, we have 81 documents. Like, this is a lot. C. Trapio Consulting, LLC versus CACI, Inc., Middle District of Florida, 2024. Ooh, that's recent. That's December 2024. Stating that successive motions for summary judgment are disfavored and allowed only within the court's permission, and striking a plaintiff's successive motion for summary judgment under the court's inherent power. Absent express approval of the court and upon showing of good cause, the parties in this case will be allowed to file a single motion for summary judgment by the dispositive motions deadlines. Footnote 3, see Awodaya 2021, 2, explaining that a good reason is needed for any district court to allow a second summary judgment motion. Any motion for summary judgment must comply with the word limit and evidentiary requirements set forth in the local rules. And I have those on my computer. See Northern District of Florida Local Rule 56.1b, setting an 8,000 word limit for summary judgment motions and requiring the moving party to file any supporting evidence not already in the record. Accordingly, it is ordered: plaintiff's motions for summary judgment and supporting memoranda are stricken. Prior to this dispositive motions deadline, plaintiff may file one summary judgment motion that addresses the defendant's counterclaims and plaintiff's claims. So footnote 3, the court previously denied a motion for summary judgment filed by defendants, document 64. In its order, the court stated that the denial was without prejudice to defendants filing a summary judgment motion at the close of discovery. That remains true. Defendants may file a single summary judgment motion by the dispositive motions deadline. If plaintiff believes summary judgment is warranted on his own claims, plaintiff motion for summary judgment must comply with federal rules of civil procedure and the local rules of the Northern District of Florida. Prior to the dispositive motions deadline, the defendants may file one summary judgment motion that addresses plaintiff's claims and defendant's counterclaims, if defendant believes summary judgment is warranted on their own counterclaims. Defendant's motion for civil summary judgment must comply with the federal rules of civil procedure and the local rules of the Northern District of Florida. No party may file additional motions for summary judgment without leave of the court upon showing of good cause. He ain't playing. This judge is done. He is over this bullshit. No, this is what happens when you F around. The judge said, F around and find out. You F'd around one too many times. You took advantage of the fact that you're filing all this shit. Guess what? The judge said no more. The judge is done. Done. Yeah, and guess what? This might be controversial, but I think they're right. But they're only half right. I think the judge is done with everybody. The judge is like, fuck it, is it August yet? Like, fuck it. Oh, no, Spawn Trooper. Sorry, bro. I gotta correct you on this one. he's not done with motions. He's done with summary judgment motions. There is still motions upon motions upon motions for every other federal rule of civil procedure that he can file. He's done with summary judgment motions. So he is not done filing stupidity, in alleged stupidity. Oh, thank you. Are you checking my temperature? Thank you. Girl, you changed it. Oh, there we go. All right. I'm normal, 98.6. No? Okay. Maybe I'm not normal. All right. No, okay, you're fine. I got it. All right, we have to get going. I have to go and do mama duties because mama duties are calling, if you know what I mean. I say they couldn't move to Gainesville. Congratulations, you just read a 6-page document in your record YouTuber time. I know, I did pretty damn good with that one, huh? Almost like I didn't have an audience and I was just recording a video. Do you want to say goodbye? And I will see you guys back tonight in like 3 hours. She spilled her water cup and then sat in it. So we have to go change the clothes. Do you want to say goodbye? Say goodbye. See you. Yeah. Say it's cold outside and we have to go change our pants. Y'all have a great day and I will see you tonight at 7:30 for something that is not not what the hail's related. All right. I will see you guys later. Bye. Oh, let me just make sure I got all the yep. Okay. Just had to make sure I got all the super chats.